Your name?
Alexander.
All right.
Your Honor, I spoke to Mr. Alexander and we've come to an agreement. The amount of rent that's owed is $2,310. Court costs of $175 for a total of $2,485. Mr. Alexander says he can pay that by next Wednesday, which will be the 4th. So obviously I'm going to give him till the 9th. We both signed the judgment and I advised him of his rights under the court rule.
Sir, is all of that correct?
Yes, Your Honor.
Do you have any questions regarding anything of this?
No.
And you did receive your right of rescission.
Yes, Your Honor.
All right. Well, court will enter that judgment by consent. All right. If you need a copy, you can pick it up at the front counter. All right. Have a good weekend.
Thank you.
103 South Hira versus Joshua Bertram.
Good afternoon, Your Honor. David Fanter on behalf of the plaintiff.
Your name?
Joshua Bertram.
Thank you.
See you, Judge.
Good seeing you, sir.
We come to an agreement on this one also. The amount of rent that's owed is $245. Court costs of $175 for a total of $420. Mr. Bertram says he can pay that by Monday. I gave him obviously till the 9th. And I was thinking that because the amount is relatively low, we should put under further orders, no writ without a hearing. Have I caught on now?
Yes, you
Finally?
All right.
So what that means is that if for some reason you don't pay, and if I file an order of eviction, the court would set that for a hearing. So
Yeah, may I say something?
Certainly.
I get paid basically twice a month,
Okay.
and it's been we're in our slow season right now, so my check has not been like half of what it used to be. So I'm just trying to make do with what I can, and that's how I fell behind. So I do
Got it.
apologize. I don't mean to be back in here.
Well, it's okay. Quite frankly, young man, that happens to a lot of folks. And I think what's fortunate about being in this county is that a lot of the attorneys, a lot of the judges appreciate that's what happens to people. And it's really just a matter of catching up, getting yourself kind of a little bit ahead so that happens.
I'm trying my hardest, sir.
No, I got you. So your slow season, when will it pick up? Like April?
I think March, April.
Okay.
When March Madness starts to begin. I worked for a printing company, Underground Printing. So after like Amazon orders are done with through December, like the end of December, we start slowing down through July, February, and March.
Got it.
And then once the school season starts again,
Then you
we
pick
start
back up.
work.
Did
So
they order any like Maryland gear to print?
Maryland?
Don't say confused.
just say yes.
Don't look confused.
Yes.
Just
Yeah,
call it that.
yeah, no, we print
It's like
we print all of them, yes.
Anything with it.
What'd you tell him? Just say yes. Just say yes.
University of Michigan, MSU, we do Iowa, we do,
MSU.
About everything.
That's like Spartans.
yeah, that is.
Yeah.
We do everything.
That'd be easy to print.
You
Anyway.
guys want.
All right. Okay, sir. So you have no questions on this judgment. I'm going to enter the judgment by consent. All right. And so if it doesn't pick up right away and you're back, you're back. We'll get you through it. Okay.
I've dealt with Mr. Bertram before. He's always easy to deal with and we always work something out.
Yeah. And just getting there. So
just getting there.
just getting there. All right. You take care of yourself, young man.
Thank you.
All right.
Thank you, Mr. Bertram.
Where? Why?
Because she was not.
Lacey's in Zoom. Why is she in Zoom? Oh, she's someplace else. What? What? She said she's not coming here to see me. She wouldn't make it in time.
We did start at 12.
Did she know she didn't? She knew she had 12. Why?
That's a question.
Where is she? Do you know where she is?
Detroit.
Did she tell? She's in Detroit?
Yes.
That's a big place.
It is a big.
That's all for me at 12. I'm
But
covering
you're gonna cover at one,
yeah,
right?
for Sydney. Yes.
Okay. All right.
So I'll see you in an hour. Thanks.
All right. Thank you, sir. Arbor Meadows versus Akio Fujimaki.
Good afternoon, Your Honor. Gabriel ACP 79685 for the plaintiff Arbor Meadows.
Did you hear us talking about you?
Yes, Your Honor, and I do appreciate you allowing me to appear via Zoom.
You're more than welcome. All right, Mr. Stringer.
Yes, Thomas Stringer appearing on behalf of Akio Fujimaki.
All right. I have a dismissal.
So, Your Honor, if you could
Yeah.
allow me this time to address Brother Counsel, I had a family emergency, and I do apologize. I did not get to reach out to you and let you know that we were dismissing this case. And we will not be bringing up the other cases.
You have any objection to that?
Well, I have no objection to it being dismissed. My client did want me to ask for fees. You reserved them. I've had to come back again. When I look at I looked at my time after today, I'll have between $1,200 and $1,500 into this. It's unfortunate that my client gets charged for that.
Do I have permission to sign your name?
Yeah, I will
Do you
state
have
that,
anything to say to that?
yes, Your Honor. I will state that this could have been resolved if he had just paid the court cost with notice. And my client was willing to do that and waive the late fee. I was willing to be very amenable, and at this point, decided to just do a courtesy fee waiver for the court cost. And I do not believe that fees should be attributed to my client, as my client's just trying to assert their rights as a property owner and keep the place where he calls home beautiful.
Yeah, but remind me, were the court fees due?
There were court fees, but the issue was Your Honor did not specifically award them in the
Correct.
last case. That's what it was.
Right, but that's part of the problem. And Ms. Lacy, I appreciate that you, an emergency counsel, has been out here twice, and I was extremely skeptical of the argument that was being made at the last hearing, because everything was settled. And quite frankly, I don't know that Arbor Meadows should have been coming after him for something that wasn't contained in the written agreement or judgment between the parties. And that was part of my problem. And now we are back here again. And
I appreciate counsel having some family issue, but somebody from the firm could have sent me a dismissal, and at least I wouldn't have had to come out here today.
In this courtroom proceeding, the judge reviews a housing dispute after both parties report that they have reached an agreement regarding unpaid rent and court-related costs. The defendant confirms that he understands the terms of the arrangement and indicates that he has no questions about the judgment. The court then formally records the agreement as a consent judgment, signifying that both sides have voluntarily accepted the resolution. Before concluding the matter, the judge briefly acknowledges the financial difficulties described by the defendant while stressing the importance of complying with the payment schedule approved by the court.
And that's what's inherently wrong about this. And I'm not blaming counsel, but obviously she works for a firm who decided to file this. And really, there was no merit to filing this. And saying that Mr. Fujimaki could have paid the fees, well, he wasn't ordered to pay the fees, and we never agreed to pay the fees. So this is just wrong. I'll leave this up to the court.
And Ms. Lacy, I get the family emergency, I get all of that, and you kept the court apprised that you weren't going to be able to be here today. I wasn't sure what was happening on the case. So that I'm not I think all of us that have been in practice realize stuff happens, right? Okay, so I get that. I appreciate though what Mr. Stringer's saying, that somebody could have sent that. I am also, how do I want to say this? I'll put it this way. Sometimes people are sent in to give arguments that may themselves not have a whole lot of merit, and they have to just go about doing their job. And I can appreciate that. And I don't fault attorneys when they're placed in that position. I may be wrong, but I think, Ms. Lacy, you always give very good, cogent arguments grounded legally before this court. I felt, well, I'm just going to say it, and I don't know if I'm right, but I think that if it were up to you, we wouldn't have been here last time arguing. I think somebody has put you in that position, and unfairly so. I say what I think. I think you were put in that position unfairly. I don't think you would have given me that argument, because that's not what you do. But Mr. Stringer and his client should also not be. So I'm not going to award the $1,500 or whatever it would be, the 15 to 20. I will award $500 in attorney fees that will need to be paid by, I'm going to say is that it needs to be paid by the plaintiff to the defendant's attorney.
We have a time frame, Your Honor? 2 weeks, a month?
Yeah.
Whatever the.
Pay it by March 16th, 2026. All right.
And I just want to put something on the record that I've had my assistant check every day for the last few days to see if we were receiving anything.
Right.
Because originally she was going to, and I'm just not blaming her, going to file a brief or file an amendment to request an amendment. So there was just nothing ever, and the dismissal could have come. I mean, from somebody.
And I'll say this, and I'm not here to defend Miss Lacy. I'll just say this. Hey, if she could have, she would have. I have no doubt in my mind. And I think that there may have been outside things hampering her. So I don't hold her responsible. That's why I phrased it the way that I do. I don't think that comes, I don't know whose pocket it comes out of. I'll make this clear in my mind. It should not come out of Miss Lacy's pocket. Whoever did what they did, that's who should be paying it. Because I don't think she would have done this. She's never done that in the years that she's been practicing.
I fully accept that. I have no ill will at all.
I know you don't. So, and it's a good thing that this is the attorney on the other side, because this could have gotten real ugly. So, all right.
Probably true.
Yes. Thank you.
Thank you.
And Miss Lacy, I'll say this. Mr. Stringer doesn't come out here that often. He used to come see me all the time. Now it's every once in a while, here or there. So the very fact that it didn't get to him and I got to see him again, I'm okay with it.
Mr. Stringer, my sincerest apologies, and I do thank you, Your Honor.
Well, and I appreciate that. And again, there's no ill will whatsoever. I think you're a fine attorney. Just things happen.
Things happen. All right. Thank you.
Thank you.
$600.
500.
No. $600 from Ava Meadows to requested me is officially gone. $600 is
That's in the other case. Isn't it?
that is stated.
Oh, yeah, no. This case is being dismissed.
This case is big.
That's what he's asking about, the $600 that they requested.
Yeah.
Absolutely.
All right. Thank you.
Thank you, Your Honor.
Field Properties versus Matata Patrick.
Gabriel Lacy for Bill Properties.
Not checked in.
They have not checked in. Would you like to take a default?
I would, Your Honor.
Raise your right hand. Do you solemnly swear or affirm testimony?
At this point in the hearing, the judge addresses a dispute after learning that the plaintiff has chosen to dismiss the case. The court notes that the matter likely should not have been filed because the fees being pursued were not included in the original written agreement or prior judgment between the parties. Consequently, The defendant's attorney explains that his client incurred significant legal expenses by being required to appear again in court. After reviewing the circumstances, the judge determines that the situation was unjust and orders the plaintiff to pay $500 in attorney fees to the defendant's counsel. In the following case, the courtroom focus shifts sharply to a far more serious issue. The court prepares to consider allegations involving alarming threats made toward a school. As the hearing begins, Judge Simpson evaluates strict pretrial conditions, including a $2 million bond and restrictive house arrest. As the proceedings continue,
Ron Pring on behalf of California.
Andrew Childers appearing on behalf of PPR.
Your name, sir?
Jules Calhoun.
All right, thank you. All right, this is the, it's entitled People's Ex parte Motion for Modification with Bond Conditions. I don't know that it was as filed ex parte in any respect whatsoever, because I think it was communicated to all parties. That's the first problem. The other issue is that typically these motions are filed, court's first determination is whether or not the necessity for the court's action constitutes an emergency. I'll be frank with you, I'm not convinced that it does constitute an emergency, but given everything, the court is choosing to hear the matter. I really don't deem it an emergency, so that you're clear on the court's perspective. All right, but is your motion? Go ahead.
All right, before I begin, and thank you for that, thank you for accommodating this motion. Because I'm a little unclear. I talked with Ms. Gaines and Ms. Scott from the defender's office. My understanding is there was one order, and then and I think there was an error or an issue with what are specifically the defendants with respect to GPS tether and exclusion zones. What are those conditions if nothing changes with respect to the defendant's bond as we sit here today?
The original order that was entered by the magistrate on the 28th, and I'd have to go back and look at the hearing, but I don't know that there was necessarily an objection from the people, was for location tracking only on a GPS tether.
Okay.
That subsequently, and again, I'd have to go back and look at the hearing. I did not have the time to review the video of the hearing. That has subsequently been changed to exclusion zone with location tracking only. So the change wasn't to, well, just added an exclusion zone. And the only area that was added, which again doesn't, when I look at the requests, the written requests that were made by the people, doesn't make much sense to the court, given my knowledge of the area, is the address of Hazley Elementary School, Ann Arbor. That particular address is the hot zone.
Is Hazley Elementary School.
Is Hazley Elementary School.
And so that, as the order currently stands, if the defendant were to be released, there would be exclusion zone of the elementary school on its GPS tether.
As I read this order, yes, but again, given my knowledge of the area, I have concerns about how this is written, because and I'll just lay it out to you. I mean, I'm one that is full disclosure. Hazley Elementary School is my elementary school. I know people didn't think it existed way back with the dinosaurs, but it did. There are 4 entrances to, basically 4 access points to the Hazley School grounds that come off of different neighborhood streets into there. So listing just the address, I don't know, quite frankly, is specific enough to cover the area. I mean, for the most part, most of the people that, if they were walking there, would not enter necessarily off of Duncan Avenue. They just, so. So that's what I have.
Okay, and thank you for that, Your Honor. I know, obviously, we were with each other less than 24 hours ago. I know
We were.
Court operates, and that's why I wanted, before we get into anything, I just wanted to make sure that my at least is correct as it could be. So the motion that was filed by my office last night is requesting a $2 million bond with the otherwise with a house arrest with GPS under release, and for him to not be within a mile of any school. That would be the request. The concern, my understanding, the concern that gave rise to this renewed request, because at the time of the arraignment, that was not the request of the people, was that the learning of the defendant's.
Well, let me just stop you because I don't think that that's true. At the time of the arraignment, and this is something, quite frankly, that people are going to have to explain to this court. There was an original bond request sent for, in terms of its monetary amount, for the $250,000 cash surety. That was, as best I'm able to determine, sent on the 17th, or shortly, the original one for the $250,000. Within 5 days, there was then a new bond form for the $2 million with some other added changes. I've, as best as I could on short notice, reviewed those. What I do not understand is, and just so I'm clear, so at the time of the defendant's arraignment, both of those were before the court, before the magistrate, both bond forms. This request for the $2 million was before the court at that time. What could not be explained, and I think something that's going to have to be explained by the prosecution, is why the request, particularly for the monetary amount, is changing. Because I don't see any basis as to why, in essence, almost an 8 to 10-fold request for an increase in those 5 days when there's nothing that happened. There's no indication of any other information that came to light that might justify that.
The only response I can give to the court would be to rely upon the written meetings.
During this portion of the hearing, the court examines a prosecution request seeking modification of the defendant's bond conditions. The judge questions whether the motion genuinely qualifies as an emergency matter and expresses concern regarding the manner in which the request was submitted. As the discussion proceeds, the prosecution asks the court to impose a $2 million bond, strict house arrest with GPS monitoring, and a 1-mile restriction from any school property. The judge carefully reviews the request and notes confusion over why the recommended bond amount increased sharply from $250,000 to $2 million within only a few days.
No personal knowledge or information.
Well, okay, and I get that, but isn't that important? I mean,
I don't disagree with the court.
because effectively what you're asking me to do is to do something under the court rule, which I can't do, which is to deny the defendant bond. I mean, a $2 million bond will be effectively a denial of bond for this individual, from my understanding. I've had my mini tirade. You can go ahead.
I understand the position of the court. As I stated, I'm relying upon the pleadings that have been filed. I think that at this point, I would move my discussion on, if the court's willing to an exploration of modification of the GPS tether. Or at least clarification, hearing what the court, through its own personal knowledge and experience of the location of Hazley Elementary and the location of the defendant's residence. My understanding is that there is perhaps a residence the defendant can stay at his uncle's home on, I believe it's Ingalls, just kind of other slightly more downtown, you could say. Now, in a quick look on Google Maps, that address does appear to be within a couple blocks of Community High School. I don't know if the court is would entertain. I'm just kind of, as we do sometimes, Your Honor, exploring options on the record.
Right. No, I got you.
And so, that's kind of where what I'm looking at now. Ultimately, we have a lot of people in the courtroom. I believe the majority of these people in the courtroom are staff at the elementary school that were affected by this threat. They are concerned for their own safety. They're concerned for the safety of their students. Rightfully so. I have a child in elementary school, and the court has its own experience as such. I think that what ultimately we're looking to do is anything we can do, acknowledging the fact that the defendant may very well be out of custody while this matter is pending, that we can as best protect the children of that school and the community at large. And that's what the people are requesting. And I'm open to a discussion as to how we can best do that. And I'm very much aware of the defendant's history. I guess I wouldn't say I'm very much aware, but I'm aware of the defendant's both mental health issues and what I could say the condition that he exists in, through a brief reading of the police reports, as well as discussion with members of the public defender's office. I'm aware of all of those things.
Okay, so, and then certainly I'll hear from the defense, but there was a request that he not go within a mile of any school, right?
You have to leave the city of Ann Arbor.
Absolutely. I mean, because I mean, I even this morning was having my staff look and just try to determine whether or not that's even a feasible condition I could put on a defendant. And a mile, you can't do it. I mean, I think within really a mile and a half, 2 miles of just Hazley School, there are two other elementary schools and a junior high and a high school. So, I mean, I don't even know how that would work, to be honest with you.
Would the court consider a GPS tether with house arrest, so we don't have to play the exclusionary zone game?
I would certainly entertain it. And look at it if that's the request. And Mr. Childers, I realize you're here and I always respect the arguments that you give, and you always give good arguments to the court. I'm trying to figure out what specifically are the people asking the court to do. Because when I look at the motion, the request is really threefold. That the people want his bond increased to $2 million cash surety from the current $250,000 cash surety. They want him to remain under house arrest with a GPS tether if he's released, and that he can't go within 1 mile of a school. And so, I mean, is that the people's request, or?
Be possible if we could take a brief break. I didn't file the pleadings, obviously.
I know, Mr. Childers, and I understand that sometimes we're put in a position of having to argue something, but so that you're also clear, I mean, I take what is at least alleged, the safety of the students, the safety of the community very seriously. I can tell the people out there that people that have known me, I've been on the bench 25, 26 years. You can send me all the emails you want. It doesn't affect it. I'm going to issue my decision based upon how the law reads. So you can stop sending the emails because quite frankly, they don't get to me until afterwards and they have no effect on me. I need to know what the people want, what the defense wants, and then I'm going to make the call. And there are going to be those that don't like it. There are going to be those that like it. Doesn't, but that is irrelevant to me in a lot of ways. I'm not here for a popularity contest. And I think there are some people that need to realize that in terms of what they file before this court. I don't play a popularity game. I do my job. I will give you a break. You can take the defendant back and we'll come back out and I'll hear from the people and the court stands in recess. All right. Court recalls case of the people versus Jules Calphone.
Andrew Childers appearing on behalf of the people.
Ron Brown appearing on behalf of my client, sure.
Right.
Thank you, Your Honor. I appreciate the opportunity. I've spoken with the chief assistant, the elected prosecutor, and the position that we are requesting, I would call it modified off the written pleading. What the people are requesting is and I don't believe in my discussions with the public defender's office, this is something that they're opposing. The house arrest at the uncle's address on Ingalls, so it would be a GPS tether with house arrest. Commander Shipakasi from the jail has been or is currently in communication with the deputy chief at Ann Arbor Police and working with the uncle to have Ann Arbor Police go through the residence prior to the defendant being tethered there to ensure there are no weapons in that home. And I believe that we would allow the defendant has medical appointments at CMH and a doctor. We can figure out those details, but we would allow for release to verified medical appointments from the Ingalls Road address.
Right.
That's correct, Your Honor. We'll figure out the details and present an order to the court.
Well, you'll figure out the details of the appointment.
We have the appointments in the address. 2 at CMH and 1 with a Dr. Connolly, whose office is at 3300 Washington Avenue right now.
But are those regular appointments? So they're going to occur at a particular time or what?
Through today, for the next week, we know of these appointments. But once he's seen, we don't know when he will be seen again or scheduled again. They're intake assessments.
Thank you.
And my understanding.
That's right. What did you hear?
I'll go sit down.
No, oh, no, you're fine. I'm just saying. I knew somebody knew something more than most.
Of course. Usually
In this segment of the hearing, the court closely evaluates the prosecution's request to strengthen the defendant's bond restrictions. Prosecutors highlight concerns about community safety and the protection of local schools, noting that several staff members from the affected elementary school are present in the courtroom. The judge reviews the proposed conditions, which include a $2 million bond, GPS monitoring, and a 1-mile exclusion zone from any school location. However, the court questions whether such a broad restriction is realistically enforceable within the city and emphasizes that any ruling will be based solely on legal standards rather than public pressure.
if we allow for them to, there can be an aspect where the defendant is communicating with community corrections.
Correct.
If this particular doctor, I know appointments change and things like that. We don't need to have an order reflecting every single appointment. But the people we would have no problem provided they are verified with the defendant seeking the treatment at CMH and with his doctor.
All right. So just so that I'm clear, the request for the increase in bond monetary amount is withdrawn.
They're no longer making that request.
The request for exclusion zones is not needed only because he'll be under house arrest. All right. And then what did I say the other one was? All right. So really, the second one is just a modification of GPS tether to a house arrest.
House arrest, correct.
All right.
And Brandon Casey from Community Corrections was already sending me messages that they're aware of this address and they can.
They're aware of the Ingalls address?
Correct.
All right.
Your Honor, we've also spoken to the owner of the 110 North Ingalls address, and he has consented to the police search of his home for weapons.
All right. And that's a single.
It's an apartment. It's an apartment.
It's an apartment. Council approach.
On behalf of my client, should we approach with the answers that the court needs?
No, that's okay. I presuming you checked the concerns of the court
Yes.
and have filed with the court a stipulated order for release from custody, which the court, while in back, has reviewed, finds that it is appropriate, and that it addresses the issues both of the needs of the defendant, which is important, but also not considering him to be a risk of flight, does primarily address the issues of concern and safety for the public on this. And I would note that I believe he has a preliminary examination, or not preliminary, but probable cause conference, which is scheduled before me for this upcoming Thursday.
Yes, Your Honor.
All right, because it was rolled up in terms of time. I appreciate the parties working it out. I have signed that order. What we will do also is we will review it. We'll prepare a community corrections order so that everybody is straight regarding the GPS tether and exactly what's going to happen with that.
Yes.
All right.
So the court's aware, my understanding is it may be happening as we speak, but Ann Arbor we're sending officers to meet the uncle of the address.
To go to the address to make sure that there are no weapons, so that won't be a bar to the release. We will get that over there for those that are interested in his release. The tether's going to have to be in place prior to his release from the jail.
Understood.
So we will try to make that happen and try to make sure that if it's going to happen today, it can happen today. Otherwise, it's not going to happen till Monday.
Understood.
All right. Thank you, folks.
Thank
Everybody have a good weekend.
Thank you.